her life.
All right. Hi, everyone. We're going to talk today just for a little bit about how to know when you have a strong EB-1A case. And I think this is super important because I'm seeing an increasing number of consultations where people are coming to me after some profile building and actually have a really, really strong case. They say they're not done yet, and then some of the activities they propose are helpful and valuable and might incrementally raise the chances of approval. But then other activities that I've seen are actually somewhat harmful to the case overall, where they would be better off just filing now and not worrying about increased profile building. So getting an understanding and knowing when your case is strong and when you should file it is very valuable and very important. Um, when you are preparing for the EB-1A, remember that the core of the case, the core thing that you have to prove, is that you have extraordinary ability. And yes, there are criteria. Yes, there's case law. Yes, there's policy guidance. But the crux of the matter is that you have extraordinary ability. And this can mean an exceptional level of expertise. It can mean that you have standing at the top of your field. It can mean that you have received an extraordinary amount of recognition for some of the things that you're doing. But regardless of which angle you're looking at it, other people in your field should be looking at you and saying, yes, this person has really reached the pinnacle of their field. They are at the top. They are a top expert. They are a top recognized person, and you need to be able to make that claim in some way. Once you have that core of your case, then you look at the criteria and you ask yourself reasonably, would USCIS, remember someone who isn't in your field, would they be able to check at least 3 of these criteria off the list? Not just as a checklist exercise, but with some vetting, with some questioning, with some analyzing. Would they be able to check at least 3 criteria off the list, in addition to saying that you are extraordinary? And I know I'm flipping the script a little bit because final merits is supposed to come at the end, but I do think it's actually really important to establish it at the beginning in order to come up with a strong case and to frame everything in a way where USCIS will consistently, while reading your case, come to the conclusion that you have extraordinary ability, because that's what the entire case is about. And I know that it's difficult to determine this because even you, who are all experts in your own fields, don't work a lot with USCIS, so you may or may not know the answer to when USCIS would reasonably think this. That's why you can talk to a lot of people. I definitely recommend talking to an attorney. Like, don't leave an attorney out of the loop. Talk to other people as well, people that you've done workshops with, people in your network, people that have gotten EB-1A approved before. Really get a good understanding of where you fall in this process. And then once you have a strong profile, consider filing with that strong profile. There are a lot of programs, a lot of mentors, a lot of resources out there right now that kind of imply or even outright say, you need this, 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 and this. And they go through a whole list of checklist items and they say, if you don't have this, you're missing out because all of your colleagues have it, all your peers have it, everyone who's applying for EB-1A has it. And a lot of those things are true to some degree, like a lot of profiles do have some of these items. But the fact that you don't have it doesn't mean that you are missing out necessarily, because a lot of them are not important. I've seen many people say, for example, that you need IEEE senior membership if you are an EB-1A aspirant in tech. And that's just not true. Like, yes, many EB-1A aspirants in tech have this membership, but USCIS doesn't care about it. It's not going to benefit your EB-1A case, and so you shouldn't spend time and money and effort going for that particular qualification when it's not going to benefit you. You are not missing out by not having it. Then you get into, say, for example, media spots. You don't need to be highlighted or in the media in order to qualify for EB-1A. For some of you, it may be valuable, so you may want to direct some activities there. But, I would say at least 50% of the profiles that I handle don't have any media at all, if not more or a higher percentage. So don't worry about it if you don't have it. Sometimes adding in a few lower quality media pieces right at the end can hurt your case rather than help it. Like, I've definitely worked with people and prepared their EB-1As where they added in some media stuff right at the end, and we just dropped it. We didn't include that criteria at all because I do feel that including some of those lower quality pieces can actually cause some skepticism for the case. And if the case is already strong, it's best not to introduce that element of skepticism. Aside from all of those, like things that don't benefit the case, there are actually some things that I've seen pop up recently that actively hurt the case, and that I really, really, really recommend staying away from. I was doing a few consultations last week and the week before, so this has come up recently for me, where it became clear that the person was participating in some kind of citation mill, where they had a publication profile and they had a few like good natural citations pop up on their articles. Nothing impressive, maybe 10 citations total, 15 citations total, something around there. But the several people now have mentioned to me that they can get lots more citations before filing, and that triggers a red flag in my mind because that's not something that you can usually control. And then more importantly, especially for tech profiles, so like engineers, you don't need lots of citations. It's not actually going to benefit your case very much. So take two identical profiles. Both are senior engineers. Both have performed really critical roles at their companies. Both have patents and have done some really original, novel things that have impacted the field. And both want to qualify for EB-1A. One has 3 articles that have been cited 5 times. The other has 10 articles that have been cited 250 times. I actually don't think that there's a big difference between these profiles and the approvability rate. I really don't. Authorship is not everything. Authorship has to be taken into context. And an engineer's profile is not a researcher profile. Like USCIS is not necessarily expecting you to have lots of publications and citations. I'm not sure that it really flows to the final merits of your case either way. I mean, if you have 1 publication or 2 publications that have clearly been influential in your field through a number of citations and commentary, and I think most importantly, the subject matter that the article is talking about, then yes, that would benefit your case. But if it's just, a matter of bolstering the publication record overall with more publications or more citations, there may be like a very slight incremental difference, but nothing that's going to make or break your case. So don't stress or worry about bolstering numbers and figures and all of that. You always need to take it back to the core of your case and that main question, like what is it that shows that you have extraordinary ability in your field. So yeah, this is probably a little bit more vague than some of you were looking for. Excuse me. Like I tell a lot of people, filing the EB-1A and preparing a strong case is a lot about narrative and how you present your expertise. It's all about making an argument to USCIS. Because there isn't like a checklist, there isn't a rubric that you can guarantee that you will meet the officer's expectations and guarantee your approval. So be reasonable, tell a consistent story, show the officer how you've risen to the top of your field over time. Show the officer that you have real expertise in your field and real recognition in your field. And then as long as you can do that, you probably have a good case, and you can let the attorney worry about how to present the criteria, or metrics or numbers in the criteria or anything like that. All right, we can go ahead and open it up for questions. Jason, have you heard anything recently, anything you want me to comment on here?
So I think there's this common assumption that a strong profile is one that is packed full of activities, and a weak profile is one where the person is just like a senior executive and has high salary. But reality is the second profile could actually be much stronger than the first one.
Right. In prior practice, it was really, really rare for me to encounter or see profiles that had 6 or more criteria. Really, really rare. Usually I was claiming 4, and I was really excited if I could claim 5. And I have filed tons of cases where we just claim 3. I don't love that. I do like there to be a bit of a cushion. So 4 or 5 is pretty good, but very, very rare to claim more than that. But over the past year, like really, really recent, over the past year or so, I've seen people who are targeting all of the criteria. And they're targeting them all very systematically, where they have large volumes of activities under each of the criteria. But what a lot of these profiles are missing are those indicators of quality. Like if you have one of these profiles where you're targeting 7 or 8 criteria, and you have a huge number of opportunities or tasks under each, and they're all done relatively recently, it looks very manufactured. Like I can look at this and say, okay, this person has been doing this for the purposes of EB-1A. And sometimes it's hard to pull out those really few qualitative opportunities where you can tell that this is real, that this matters in the field, that it matters in the person's career. And if you can't pull out those few opportunities, I think people are going to have a really hard time overcoming that assumption that things are manufactured. Like when you're doing profile building, yes, to a degree you are manufacturing things. You do have to meet the criteria. So there are some things that you have to do that you wouldn't necessarily otherwise do in your career. But those things should also matter. Like they should be important in the context of your career growth, and they should be important in the context of a claim as well. Like other professionals in your field should be looking at those activities and say, oh, that's cool. That's really impressive. It should be generating you that kind of recognition. So I think I do think it's better to take the foot off the gas a little bit and focus in on a few criteria, not all of them, but just a few, and then find really qualitative opportunities like in those few criteria. Things that you can really pull out and highlight on their own so that you're not presenting just a slate of activities that you have done. I'm not going to be shocked if there's a big uptick in denials on final merits coming up in the next year or so. And I'd love to see some litigation on that topic. I do agree with a lot of the attorneys out there that are saying the whole final merits construction is illegal, like it's not a valid interpretation. But even under the interpretation we had prior, some of these profiles would be suspect. Because final merits didn't used to be an affirmative thing that you had to prove, but it could be something that USCIS brought in if it thought that you really weren't extraordinary. So I think it's going to continue to be a problem for a long time, but we'll see.
So if you have leading a critical role and high salary, let's say you have a really strong claim for leading a critical role, say your work influences thousands of US companies and directly impacts them, keeps them operational, for example, then do you already have a strong profile and just need to meet, say, judging and authorship at a plain language level?
Yeah, and I've definitely filed profiles like this where we claim 3 criteria. One is leading critical role, one is high salary. Those are both super strong. And then they have to add one, and they just haven't done that throughout their career because they've been fully focused on service to this one company. And I tell them, okay, judge the Globies, get an advisory board position, and see if you can do a thesis review. And so they have 2 or 3 judge opportunities that we can present, and then we present a case with 3 criteria, judge being very minimal and built just for the purposes of EB-1A. That works because the final merits, like the core reason why that person is extraordinary, is pretty much indisputable and undeniable. They are at the top of their field because of the position that they hold. So, I mean, it's fine to construct some small aspects of the profile, but you need that core question to be answered in the affirmative. Like you need to demonstrate that you are a top expert or someone with top standing in your field.
Ellen has a question. Common question: how do you show that you are among the small percentage at the top of their field to establish final merits?
This is a very good question. And I will say the interpretation of what small percentage is not clear. USCIS has advanced so many different metrics, vague guidelines throughout the years. They're not consistently using this phrasing in their RFEs or their denial notices right now. I think in part because it is so difficult to define. There's actually really favorable language in the regulations and in the no, not the regulations, the legislative history and in the regulatory history. So the notices, the comments that come through the notice and comment period. And it's a lot of really favorable language in favor of EB-1A applicants. So if USCIS tries to advance a definition that small percentage means like 0.1%, there's lots of ammunition to argue back against them. But it's hard to establish things in terms of percentages. I mean, you can show, for example, salary benchmarks at the 90th percentile or higher. You generally can't really get more granular than that because the data is just not reported. And then when you look at things like awards or media or leading critical role, there aren't built-in metrics where we establish a hierarchy to show where people fall. I mean, that's really not how U.S. society is structured at all. So it's all about narrative, really. It's not like you can do a particular or specific activity to guarantee that you fall into this group. You just have to tell a compelling story about how you have grown in your career and risen to the top of your field. So I know, again, it's vague, probably not as helpful as a lot of people would like, but I think that mindset shift and taking it more into the narrative is probably important for those of you that are profile building.
So when telling that narrative, should you focus on aspects of your work that would be impressive to a layperson? For example, you directly affect thousands of US companies.
Yeah. Bringing in figures like that is very, very good. Like if you can say that you drove 15 million in revenue or saved the work hours that were equivalent to 200 full-time employees annually. If you can drop name brand companies, like household name companies that you have worked for at a high level with impressive titles, like all of that factors in. All of that looks very, very good for the EB-1A. So yes, put in the numbers that will be pretty much objectively impressive to someone who is not in your field. And then bring in more narrative and explanation for why things that are very specific to your field flow towards you being among the top professionals.
So I don't see any other questions.
All right. We can live stream a bit early today. Is there any other comment or any other trend you've seen, Jason, that you want me to comment on?
So in what scenario would it be important to have authorship and judging contribute to final merits?
Yeah, if you are an academic or researcher, usually authorship and judging are cornerstones of the case. And so, if you are a researcher and those are cornerstones of the case and you don't have hundreds, if not thousands of citations, it's likely to fail on final merits. And it might seem unfair. Like I'm saying, the industry, the engineer with 15 citations can probably get approved, but the academic with 350 citations will probably get denied. I can see why people think there's an inconsistency there, but it's all in context because the industry professional is not relying on their papers to show they're a top expert. They're just asking that to be checked off the list. But the academic most likely needs to rely on the papers for being a top expert because it's going to be a core of their case. And 350 citations is not very impressive, at least not in most fields of study. And so in those cases, USCIS is going to compare them against the academic that has tens of thousands of citations and say, this is not impressive. You haven't risen to the top of your field. You are more junior, and they'll deny the case. So you have to emphasize those prestige factors whenever the criteria is core to your argument and whenever that criteria flows into what is making you a top expert in your field.
Balaji asks, does USCIS keep track of your filings? If you decide to withdraw and refine, will they access my history to make a decision?
Yeah, they will see the receipt number in your file. And they do have a copy that they can access. I don't think most of the time they're very interested in reading 2 files, but you should expect that they have access to everything and act accordingly. So there are some times where I will submit a refile and I will explain a difference that we made from the first filing and the second filing. I don't have to do that, but I assume that at some point it's a good idea to do so. But you can do different things. Like if you claimed 6 criteria in the first one and then withdrew it, you can claim 4 criteria, or you can claim a different set of criteria. It's all fine to do. Just make sure that if there's anything that looks strange or that USCIS might question, that you explain it.
Tisha asks, are you seeing more denials for EB-1?
So not me, no. I have seen a lot more consultations for denied cases, but I am not sure if this is really indicative of a trend or if it's just that more people know about me and want the feedback on their case. So I don't think I can really report in on what the trend is right now. I don't have enough information there.
All right, no other questions.
All right, sounds great. Thanks, everyone.
Thanks, everyone.